Ladies and gentlemen, good morning. It's a great pleasure to welcome you to our special seminar that is dedicated to most recent developments related to China's engagement in international economic law. My name is Joanna Jemielniak. I'm associate professor here at the Faculty of Law, and I'm going to conduct today's seminar together with my friend and research partner, Dr. Xiang, assistant professor at our faculty, and we are very, very fortunate to have a highly distinguished panel of speakers specializing in different areas of international economic law with us today. We have Professor Julien Chaisse from Hong Kong, and Helena Chen, the head of the Beijing office of Pinsent and Masons and the renowned arbitration specialist. We have Professor Vivienne from University of Sydney, a great expert in international economic law with a focus on investment law and on China. And we have Mr. Libin Zhang, who is a deputy director of the Institute for Energy Law and Policy Research at the Peking University and partner at Broad and Light. Who is a great expert in energy law. So we have a number of areas of international economic law represented here by our experts, and we are very much looking forward to this roundtable. So the formula for this seminar is to discuss together the issues that are related to the broader picture of China's engagement in the global trade, in the global investment policies. And I believe the seminar couldn't actually start without the question about the Belt and Road Initiative. This is such a major undertaking. It's unprecedented in ambition, in scope. It has been dubbed the new Marshall Plan without the war. Actually, the scope of this initiative exceeds the scope of the original Marshall Plan. It's going to cover 3 continents. It's going to affect more than half of the world's population. And of course, here in Europe and here in Denmark, we've been wondering to what extent does it affect us, and how does it affect the Nordic countries? How much does it affect Denmark? If you could possibly comment on how do you see those different levels of engagement of the European countries in the upcoming Belt and Road Initiative, and what are the lessons from it for Denmark?
Yeah, I can start. Yeah, thank you. Thank you. I just want to speak first. So to 抛砖引玉, to throw the bricks to attract your jade. You know, I think the issue is really, in a very broad perspective, that it is, good for the European countries, including Nordic countries, as we know that the TTIP, negotiation suspended somehow, for the relationship between the Atlantic Ocean between U.S. and EU, and in the U.S. there is a sort of a protectionism, led by Trump, which is going backward, and I think that at this time when EU probably strategically is actually being pushed somehow either passively or proactively towards a more closer cooperation with China. And at the time when China is initiating this, broad and, the Belt and Road Initiative, which has, actually been started for 4 years already. And so this, I think, strategically is good for EU. As you can see from the media, the response is very positive. You can see, the Macron response, first, as a, a EU state, very much, responding to Xi's, request. And so is the other countries like the UK. The UK is also promising some, financial support for the UK companies getting involved in the initiative. And the Eastern Bloc countries actually also, being sort of caught in the slow progress in the economic situation within the EU, is now hoping that they could probably benefit as transit states for the Belt and Road, outbound investments and trade. So the overall response I see is positive, although there are some concerns about the competition or other, some negative messages. But I think that this is, if you look at this, in a broad sense, that China is trying to do this, not in a one side thinking, but the win-win situation, more cooperative. I think that the EU countries, including Nordic countries, and China has a lot to supplement each other, especially towards the China's next wave of foreign investment, economic reform, and this is reflected in China's new vision of China made in China 2025, which I think is setting up the targets for China by 2025, and I think the EU Chamber of Commerce, chairman, is calling on the European companies to actively participate in that action plan. And I think that this is something which we will see, and I'm very positive about it.
I might take a bit of a different view of looking at the Belt and Road, I think, because everyone has got so keen on talking about the Belt and Road Initiative that nobody really seems to know what it is or what it does. And of course, it's really very vague and very amorphous if you go back to the original documents. What it is essentially based on is the concept of connectivity. And that then raises the question, in terms of connectivity has to go more than one way. It has to go in several directions, ideally. And so there are still, I think, a number of questions about the Belt and Road and how it's going to turn out. The first question is this really a way of dealing with China's enormous overseas workforce of people who go around producing projects? I think there's at least 7 million Chinese workers whose main role in life is to live overseas and to conduct railway and to build railways and roads. And in that case, part of the purpose of it is essentially to use Chinese overcapacity and to keep Chinese workers busy building projects. If that's so, then it's not so much connectivity, it's more something which is essentially based in China and is advantageous potentially for the Chinese economy. On the other hand, if you look at the initiative and you say, well, the purpose of this is going to be that new links will be built across Asia and from China across to Europe, then obviously opportunities open up to all of the other countries along the way. In that case, it's not so much a China-centered initiative, but it offers opportunities, for example, to Middle East, to the Middle Eastern countries, well, not really Middle Eastern, but Kazakhstan, Uzbekistan, Georgia, other countries which may not have been so well along the road or so well linked to other parts of the world to in fact make better connections. And that obviously offers opportunities for European countries as well, because it means that they too will have better opportunities in order to, say, export goods to those countries, to set up projects in those countries, and generally to encourage investment. Then there's the question of strategy. Is it in fact a strategic initiative? Is the purpose of it for China in particular to be sort of at the centre of a whole link of connections and roads, so that the networks now centre more around China than as they traditionally have around Europe and the US? And in fact, if you look at it, there's probably no harm in having more things centre around China rather than around the traditional bases of the US and EU. If you look at the Asian area, China, Indochina, the Asia-Pacific, that is a total economic powerhouse, and a strategy which allows that area to actually benefit from that and spread those benefits around would be a good thing as well. So I think we have a number of questions about the Belt and Road, but I also think that we need to think about it in a different sort of way. Think, what ultimately is it? What will it do? And what advantages does this potentially give? And I think if we look at it in terms of connectivity, improving infrastructure, allowing links to be built between countries, then there are certainly substantial advantages that can accrue to all of the countries which have some links somewhere along the way.
I'd like to share with you my personal experience. What I'm talking about is actually the cases the projects that I have been personally involved in. As I reported yesterday, Pinsent Masons, compared with other international law firms, we ranked as #1 in terms of the number of OBOR projects that we assisted our clients and reported to the lawyer, the journal. Say, for example, the OBOR projects. A lot of projects are relating to power plant because those countries, they are in need of development of their infrastructure, of course, include power plant and maybe highway, high-speed rail, etc. And to take the power plant as an example, they do not only coal-fired power plant, but also wind turbines. Who provide wind turbines? In Denmark? Zhang Energy, right? it's a huge company, yeah. And then the Chinese SOEs, when they invest in the wind farm project, they need to purchase equipment, the wind turbine, from maybe Zhang Energy, maybe Gamesa in Spain. Those are European countries, yeah? And then those European suppliers, they provide high-tech equipment, and the amount in those purchases is actually huge. Yeah, that's one of the way, not only by China, but also by Europe, by those advanced equipment from European countries. And the other way that European countries may be involved is the investment from China. 3 years ago, Pinsent Masons conducted a research with regard to the China's investment in UK, because Pinsent Mason is headquartered in UK, so we did the research in UK. We analyzed the industries that might attract the Chinese investors' interest. Of course, the high-tech industry is one of the field that would certainly attract Chinese investors' interest and appetite. And I believe similarly, say German, or maybe also here in Denmark, I believe there should be some industries that would suit the Chinese investors' needs and be appealing to them. So I believe that a similar project similar effort can be made in those aspects. And then, say for example, I from time to time would need to meet people from the UK's International Trade Commission Department. They send people to mainland China to understand what are you interested in. Yeah, so that's another angle. And then the last but not of the least importance is dispute resolution. For example, I have seen, say, ICC. They sent the vice chair of ICC to mainland China to run all kinds of events to promote this institution, to promote their dispute resolution service. And similarly, say in April, I know that SCC, based in Stockholm, they are also sending their delegates, high-ranking people to mainland China, to Chengdu, and not only in Shanghai or Beijing, the cities that you might be more familiar with, they are sending people to Chengdu, to Shenzhen, to promote their dispute resolution service, to say, hey, you can consider us when you are entering contract with, say, European companies. So there are a lot of opportunities, and people are, I believe, people are tracing those opportunities eagerly. And I think this OBOR related project and the sheer amount and the scale of the Chinese investment, outbound investment in the coming years, certainly a lot of people are tracing opportunities from those projects.
Yeah, thank you. I'm glad that you started the BRI actually, because I live and work in Hong Kong, where people are talking about the BRI every day, quite a lot, but I also share many of the points made by the colleagues on the panel, which is that essentially the BRI is a quite vague project, which could become something extremely important for China and a number of countries in the world that are involved in the BRI or not. Well, it could also become something that could be disappointing at some point. So starting with that, I'd like to make two important points. I don't want to repeat what the colleagues have said. The point number one, which I believe to be important when we try to think about the potential of the Belt and Road Initiative, relates to the law and the existing law, in fact. There have been a lot of discussion as for whether or not China will engage in new negotiations to craft new rules and to negotiate new treaties. It doesn't seem to be the trend, at least on the near term. And this is where I find very interesting to look at the treaties that are already existing, because there is a number of treaties that are in place dealing with investment issues or trade issues that are going to experiment what I would call a kind of second life. Take the example of treaties on investments. Joanna was asking about the potential impact of the BRI on Denmark. I cannot predict what are going to be the projects that are going to be conducted in the coming years. But what I can say is that whenever there'll be investments made by the Chinese companies in Denmark, there'll be one treaty applicable, the treaty that was signed by Denmark and China somewhere in 1985. And that treaty was perhaps not, the most exciting legal documents in the past years. Perhaps it did not cover a great number of investment projects, but precisely the BRI might, in this case, revive this treaty, which was not designed in 85 or even earlier to implement the BRI, but it will serve this purpose. And I think that we are going to see this also in a great number of other countries, closer to China, Kazakhstan and all the STAN countries. I could also take another example to say that many treaties are going to have a second life. I think the most important would then be the World Trade Organization, because when it comes to trade, the WTO remains central, even if it has had difficulties in the last years to develop new rules. But its mechanism to solve disputes is working pretty well. WTO law covers a great range of issues, from property rights to subsidies, dumping. And the BRI will certainly serve the purpose of the Chinese government. It's going to be a tool to open up a number of foreign markets, to ensure that a number of standards in the BRI countries or sanitary measures do not constitute obstacles to trade. And that's also something very interesting. WTO, which was a bit perhaps moribund in the last years, may also have a kind of second life because of the BRI. And what I find to be very interesting from the lawyer's perspective is to see how China and its exporters or investors will use these existing treaties. It's going to be, I think, very interesting to see what new strategies are deployed to take advantage of the existing norms. Let me just conclude on this very first point by saying it's also fascinating, because that's going to be a kind of paradox. Many of these treaties that I mentioned, those on investments or the WTO, were designed to impose something on China. When China joined WTO in 2001, it was at the cost of very expensive commitments and compromises. And the beauty of the wall, if I may say, is that the cost for China to join WTO may well soon become an advantage to implement the BRI. And I think the same logic would be true when it comes to investment treaties. Back to Denmark, China, I'm pretty sure that in the 80s, Denmark was in demand of a treaty on investment to protect its investors in China. And now we are going to see how that treaty will be used for the Chinese benefit. And perhaps a second point, very quickly, so as to show I'm not just a law professor, but I can also think about geopolitics and the implementation or the implications of the BRI. I think Vivienne touched upon this, and I think it's very important. She mentioned the strategic dimension of the BRI. I think it's something that we should not underestimate or exaggerate, but that's very important. And of course, when we talked about the BRI, commentators focus on the number of countries which have been identified as being part of the BRI. And they give the number of 65, which is supposed to be very impressive. It is impressive. But in politics, what I find to be interesting is also to look at those who are not in the club, who are not included in this initiative. So again, we have to be very careful because we don't know how important the BRI will become. But I believe to be also very interesting to say that the US is not part of the BRI. India is part of it, Russia is part of it, EU is part of it, but there's a number of jurisdictions which are not, a number of, let's say, trade powers which are not part of it. And I think it's also important to take this into account. I don't know exactly how to assess that, but I think it participates in a kind of global shift in terms of power and the use of trade to exert the power in the world. The US tried to use its power on trade with the TPP and failed, at least for the time being. And China is using some of the tools to also exert a leadership here, which is very interesting. And I think that if we take a bit of distance, what's happening with the BRI is very interesting because the US is a bit in retreat. Japan is struggling with issues of economic stagnation for now many years and a number of other social issues. The EU is trapped in the Brexit dilemma, and China, a bit by default, perhaps not by design, is emerging as a trade power, which will have a big impact on a number of decisions in the coming years.
Well, thank you so much for those comments, and I would like to possibly follow up on your comments, Julien, related to the multiplicity and this diversity of regulatory framework for investment that we are already having, this multiplicity of the existing BITs. In the context of the EU and Chinese policy related to Belt and Road, and in a broader sense, like mutual investment relations. Because the Belt and Road Initiative was announced for the first time in 2013, and that was also the year in which the EU has largely publicized this project of concluding a comprehensive agreement on investment with China. And this raises a question because those negotiations are officially still on, whether those two initiatives, the Belt and Road, that is clearly a flagship of the Chinese trade and investment policy, and the investment pact promoted still by the EU, whether these are competing visions of investment policy, whether they are or whether they are complementary. Would you comment on that? Perhaps you could also offer comments on whether you see it happening. What are the prospects of success for the
that's a very interesting question. I would try, because of the format of this panel, to go to the point, and I would say that indeed the BRI, and on the other side the EU willingness to negotiate a big investment treaty with China could be two initiatives that should converge. But I think there is a difference in terms of motivation. The drivers for these two different initiatives are very different. And that's why I'm afraid that they might not converge, actually. The BRI is still on. So let me talk just a bit more about the EU-China treaty. My understanding is that for the last month, at least 9 months, the negotiations are suspended. So the EU began with a great ambition to negotiate with China, and the goal is, to put it very simply, one, to replace all the existing bilateral arrangement, bilateral investment treaties that have been signed, let's say, between Denmark, China, Belgium, China, France, China, by a single treaty, which will provide a greater clarity, perhaps greater coherence, and also better protection for the investors of the two sides, and also greater liberalization, so greater market access, which is perhaps even more important than investment protection. And the problem is that this very nice initiative is a bit subject, it's quite subject, in fact, to the EU politics. So here the Brexit has nothing to do, but the EU is struggling, in fact, to implement its new power to negotiate on investment because a number of member states have been opposing that. And legally speaking, there remains a number of uncertainties as for whether and to what extent the EU as such can negotiate on investments. So the China-EU negotiations are suspended. I mean, officially they're still going on, but when you look at the minutes of the meeting, there is nothing happening and there is no substantive advances. And perhaps to close here, it's also interesting to understand these negotiations by looking at what the EU is doing with some of the partners like Australia and New Zealand. And very recently, the EU decided the Commission decided to submit a draft mandate to the Council in which investment and dispute settlement are excluded. So it's an indication that really the Commission has some difficulties managing this new investment power, and that may have a direct impact on the EU China investment treaties. Perhaps the colleagues want to add to that, but you see that in my view, the consequence is that the BRI is even more important. If the EU fails to develop its own agenda with China and to control the negotiations, of course, the BRI will be, again, by default, the solution to the EU-China investment relationships.
I want to add that probably, we're talking about different perspective. The BRI is more a strategic, thinking at the level about China doing more trade and investment in EU and also along the route of BRI. The investment agreement with EU and China, also the various BITs negotiation is more at the legal level that will affect the BRI implementation. BRI, if you look at it, people ask me about what is BRI, as Helena and also Vivienne mentioned, that is vague. So I think this is more like a working concept that it started as an initiative, and the initiative being proposed by one side, and then I think that the response so far is positive, generally speaking, and then both sides will have to work towards a more more balanced and more detailed concept, to contribute to that and to build on it, rather than just try and pull apart and each side go back to the protectionism. Given that what is happening in the U.S., everyone goes back to its own, and I think that that's not the world trend. I think that the world trend is still globalization, given even though there are some hiccups in some areas. But talking about the investment, you can look at it. Look at ECT, not 1990s. It is at the time when the EU is trying to expand into the Eastern Bloc countries and to make investment, and that's the mission of the ECT. If you look at what China is doing, China after these years of the economic reform and more Chinese companies are getting stronger international, of course, there is the need of doing more trade and investment, and so therefore that is the natural historical development which we have to give some sort of a recognition. It's not just try to deny that world trend. And so now the EU countries at this time, at the strategic level, should be, facing the issue, shall it be more open-minded and encourage, facing the competition from China, to be really competitive and to compete at the same time cooperate. And I think sometimes competition is not a bad thing, okay? And both sides have a lot to learn. But on the other side, I think that EU has its own laws and regulations regarding environmental and labor, so I don't think that Chinese companies, will do whatever they like. This is when they are outside, the rules of game totally changed. Has to be a very developed legal system in EU, and I think this is also true that if China really want to deserve good legal environment protection along in the EU countries, when you negotiate those bilateral investment treaties and also multilateral treaties with EU, China got to give the reciprocity treatment to the EU investors in China. And this is what I'm saying, that this will serve China well in a way which force China further opening up. Its market sector and also its level of rule of law protection. So I think that in a way that the BIT negotiation, which is more updated, giving legal protection as well as the legal protection clauses in the EU-China investment agreement, while it gives the Chinese investor legal protection, it also serves as a double-edged sword, allowing foreign investors in China to seek the protection which is the level they expect the Chinese investors expecting EU. So in this way, I think that this will serve the world well. That China is being also upgraded in its rule of law, and I think that China, with such a big size, learning to do things according to rule of law is a blessing for the world, rather than a big giant elephant in the room, not knowing how to behave, in the room, and then and start to do stupid things. I think that serves well for the whole world's benefits and peace.
No, I think that's actually right there, Ben. But if I could add a comment on the investment treaties, I think it appears to me that for the last couple of years, China's interest in investment treaties has not so much died as it seems to have faded. So on the one hand, it's pursuing free trade agreements on a regional basis. In Asia, it's still pursuing the regional comprehensive economic partnership. It's doing various free trade agreements. It's just signed one with Georgia, for example, and there are a few regional things. And in those, it tends to not push very hard, really, for a high level of market access in the investment provisions. And on the other hand, it's got this different lot of investment treaties which it's been trying to push with developed countries, essentially driven by the US negotiations. And as we mentioned, or as I mentioned the day before yesterday, the China-Australia Free Trade Agreement investment chapter, the Korean Free Trade Agreement investment chapter, the Swiss investment chapter are all essentially waiting for the higher level of market access to be agreed with the US. And this, of course, is very much to China's advantage because these are countries in which China proposes to make investments, but also countries which have investments in China. But as far as I can see, and part of this, of course, is the US withdrawing. It appears from the world stage they seem to have lost interest in their bilateral investment treaty, but it appears to me that the Chinese have actually, for the moment, lost interest in pushing this sort of high-level investment treaty as well. So I think this is probably something which is also having an effect with the EU, quite apart from the fact that there's a limit to how many negotiators even the Chinese government can produce, I think, for their various initiatives around the world.
I have one point to add on Libin's point that the overall investment and trade relations between the Chinese and the European countries are actually impacting the overall legal environment in China. For example, I don't know if you are aware that there has been precedents that the Chinese court recognize and enforce court judgment made in Germany. Yeah? And then I believe there will be more to follow. Some of the cases are relying on the conventions of mutual judicial assistance between the two countries, between China and the other country, or maybe based on the principle of reciprocity. And then, we have been seeing more and more cases that court judgment made in a foreign country can be recognized and enforced in mainland China. I think that also reflects the need in the trade between Chinese and other countries. So I think that's a good circle. Yeah, that's a good circle, and that's one thing. And the other thing is about whether the Belt and Road Initiative is something just the people talking, very high-level strategy, or does it really have impacts in practice? From my work, I believe that it does have impact in practice. For example, if the project is the MOU of certain project is concluded when, say, Mr. Xi Jinping or some very high-ranking politicians visit that BRI country, and then they sign the contract. With that fact, then the Chinese SOE involved in that project can say, oh, this is in Chinese so-called 高仿项目. That's a project that's being, the MOU or the agreement of that project was signed when Mr. Xi Jinping was there in that certain country. So that just with that fact, the Chinese SOE can get a better interest rate when they try to get a loan from the Chinese bank. So that's important. Because I think in China, this kind of big investment is actually supervised or guided by the overall national strategy. So that does have certain impact in practice.
Thank you so much for all speakers. And I remember Helena has mentioned very briefly in this first question about the name of Dong Energy, which is state. I mean, if you read the name literally, it means Danish oil and natural gases company. It's a state company in Denmark, state-owned company in Denmark. And now they have changed the name to Ørsted because of they would like to get rid of this dependence, reliance on the fossil fuels. So would like to kick out the oil and natural gases. So that can be seen actually as a trend for the world to accept a cleaner, a no carbon economy. So in this context, I think China actually has played a very important role, or even the leading role, in the global renewable economic race. Taking into account of China's internal pressure to combat the air pollutions and other environmental pollutions issues into consideration, and also China is aiming at fulfilling its international commitments. Such as the latest one is China's legal commitment to the Paris Agreement. As we all know that previously that for those developing countries and including China to not have obligatory commitment to reduce the greenhouse gas emissions according to the Kyoto Protocol. But now things have changed. So China has made a legal commitment to peak its greenhouse gas by 2030. According to its commitments under the Paris Agreement, still on a voluntary basis, but that's a huge achievement has been done by China. So as we have seen before, that China has playing a formidable role in the renewable energy sector. So we are also seeing the trend that China is also exporting its new model of this renewable energy issue. I would like to ask our panelists about what do you think about the global implications of China's concept of the greener and no carbon economic way of growth for other players in the world.
Can I just first be the first one to respond to that, given that I'm first in a row. The Chinese green energy system in the context of the BRI has three dimensions. One is the climate change. Second one is environmental protection. And third one is the energy conservation and energy transmission. When you look at domestic Chinese energy situation, China is having two purposes for right now what's going on in the energy sector. One is the energy liberalization, breaking up the monopolies and increase the efficiency of the sector. This will also mean that China will open up and get more private investors and combined or mixed players to play or cooperate together with SOEs in China's energy sector. This is liberalization. Second perspective in China, domestic energy reform is energy, a transition to a cleaner energy, and I think that's what is going on. So we look at, from reducing coal, increasing, renewable energy, and increasing gas, which is cleaner than coal. I think you see that development. Okay, but at this current era in the world, no energy issues is only domestic issues. It has to be international. So that makes things very naturally put things in, this issue is not only a China issue, but this is also a world issue. And that is reflected in our thinking of, how BRI will play in the green energy, sector, when what's China going on. So if you look at what is China doing right now, given that China will continue to rely on the crude oil import from the Central Asia and other countries along the route, which I think is strategically important for China, and that has been going on for years, even without talking about BRI. But China has also increased investing along the BRI countries in the renewable area, like the solar and wind, and also nuclear, as you see, the investment in UK, and also a lot of investment, water and solar renewable projects in Eastern Bloc countries. So you look at those things. China is actively, knowing that the world, it has this need for green energy. China cannot really just transfer its extra capacity, which they had in China, with a lot of carbon and environmental externality cost problems. So China cannot just simply substitute those things outside and impose on the world. That doesn't work really. So China got to be aware of that, and given that that's all becoming a political issue both in China and outside China, and so I think that I'm positive on that, and I would see more cooperation, and I'm happy to learn yesterday from Professor his name is Bellman, right?
Joan
Bellman, yes. He mentioned that the Denmark being so successful in having renewable energy providing power, which actually becoming having a surplus net exporter, so successful in that, and has already helping China in establishing a renewable energy center in China. And China is looking towards learning to Denmark as to how to make that happen in China, to reduce the coal but increase renewable energy. And I think that actually is a typical example of how the EU countries and China can work together to help China to get a greener energy. And I think that could be be structured as both a state level demo projects as well as commercial projects, which happens in various at various enterprise level.
Yeah.
No, I don't have a lot to add to that. I mean, obviously there are a lot of positives. Point one, if China can reduce its amount of pollution, that would have a major impact on its neighbours, for example. That would be very positive for it. And similarly, if it's going to put money into renewable energy projects along the Belt and Road, that's a very positive indicator as well. I mean, there are already advantages in China's focus on this. So, for example, the price of solar panels in Australia has come down so much over the last 5 years that now it's really quite feasible for anyone who wishes to put a few solar panels on the roof to offset the enormous price of Australian power. But I'd point out, I think that a lot of the implications are actually going to be a bit unpredictable because China is now so large in terms of the world economy. So, for example, the latest movement to stop people burning coal means that China is now importing immense amounts of natural gas, thus pulling it away from other markets. So, I mean, going back to Australia again, we're a natural gas exporter, but so much of it is being exported that the price of gas domestically has just rocketed over the last few years. Similarly, it has effects on the economies of those suppliers who have traditionally supplied oil and coal to China. What happens to that if the market for those products all of a sudden collapses? So the thing about Chinese policies is that when you implement them, you're meant to implement them immediately. And as we've seen, the way they're implemented can be a little bit unpredictable. So although I think the overall long-term effect should, I hope, be extremely positive, I think we have to be aware that there are going to be some question marks along the way. Other economies are going to have to be able to react very promptly to what happens in China as a consequence of the implementation of these policies.
Well, Vivienne actually just mentioned the point that I'd like to make. I'm based in Beijing, and for this summer, I believe Libin would agree with me that we are experiencing the most beautiful winter in the past 5 years. The smog in Beijing has been so notorious that everyone knows living in Beijing is not easy. But this winter, we have more blue sky than ever. In the past 5 years, and one of the reasons is that the government forced the people to abandon coal and then to use LNG as the source for heating. So naturally, the price of LNG has gone up significantly. But however, as far as I know, in addition to using LNG, the Chinese SOEs, those big energy company like Jingfeng, Goldwind, or Datang, etc., those big power companies, they are also trying to say by M&A. I cannot talk too much because it's M&A, it's confidential. What I can say is that those Chinese SOEs, they are purchasing the companies of other international power equipment supplier, big power equipment supplier company to. By doing those M&A, they want to purchase the most advanced technology so as to produce cleaner energy in mainland China. And with those, bundled with those projects that maybe if you agree to work with me on this project to sell me this high technology, and I would agree that for a project in Pakistan or in some OBR country, I would work with you in that country as well, etc. So all those terms are bundled together and under negotiation. So that's a very interesting period of time for people, for lawyers doing M&A as well.
That's perfect.
Well, I'll be brief. I think we should conclude, on that question with your description of the Beijing sky this winter, which is very positive. But let's say you have said already many things. I would simply add, from a slightly different angle, what's happening in the field of renewables, what's being done by China is also very interesting because some of the countries are in denial. Think about the US, for instance, of course. I don't want to look like the guy who's against the US. Already twice this morning I say bad things against the US. I have nothing against the US, but it also makes sense to look a bit beyond China, to assess what's happening and compare to some other players. And yes, some other countries are in denial or in atrophy. They don't do much while they know what the needs are. And I think it also gives to the Chinese policy with regard to renewable energies a political dimension, which is quite important because it's giving a direction where, in a time where there is perhaps some chaos in the world. And I think that is in itself quite meaningful, in fact. It's really a suggestion of that China is taking a lead in that field too, which will have implications in trade and investment once again.
Yeah.
Can I add something?
Sure.
Please.
Before we move on. If you look at what happened in China in terms of renewable energy, it's very interesting. Okay, China has been using coal as a dominant energy source, and according to yesterday's statistics which was released somehow I just get this morning, China coal is 60%, and energy mix. Over the years, China has been relying on coal and then crude oil import a lot from Central Asia. Natural gas, China is short of and never been a major natural gas consumption. And the recent years, because China is trying to increase the natural gas consumption to catch up with the world average from 6%, upwards. I think that China is actually buying more gas and building more LNG terminals. But given that China doesn't want really to rely heavily on natural gas from abroad, which doesn't give China's energy security, China is trying to diversify the gas supply, both from the pipeline gas from Central Asia and Russia, as well as diversify the LNG supply from overseas. Not only Australia though, but also the Qatar, and also even the U.S. is now already starting shipping LNG from the shale gas industry to China right now. So China also, because of the recent deal which they reached with Trump, China for the first time has participated in the Alaska LNG upstream production. And I think that's all these are the positive signs that China is trying to participate more actively in natural gas. In spite of that, okay, there are views that China should not rely too heavily on natural gas, and I think China is betting on renewable energy. And according to my discussion with some entrepreneurs in China in solar, especially from Jiangxi province, the Jiangsu province, which is very good for a solar industry, they are saying that the cost of the solar within 5 years, probably a little bit aggressive, someone put it in 10 years, that they could be as competitive as coal power. If that happens, I think, according to Chen Weidong, who is a top economist of former CNOOC top economist, he said that China will probably skip the natural gas era, not from coal to the gas era, but directly from coal to renewable energy. And I think that's very bold, that's a bold strategy, actually. I think that may happen. And even the state grid, which has been, over these years, has been a conservative player resisting the liberalization, has now changed the attitude to look at the renewable energy and distributed generation and also smart grid as to what they can do proactively. So they have changed their mind too. So I think that the industry is changing actually probably faster than what we expected. And I think that will probably, after 5 years, when we come back to discuss these issues, I think that the situation will also change and the context will change.
Actually, I'm quite happy to. I've been quite happy to hear basically all the panelists already referring to the problem of dispute resolution, which is very close to my own heart, in the context of the Belt and Road Initiative, of course, what Vivienne has said, that it's such a heterogeneous initiative. It comprises of so many different forms of collaboration, investment, trade flows, that it is difficult to pinpoint a common agenda for those different forms of collaboration. This also translates into difficulties with finding proper mechanisms and proper venues for resolution of the disputes that will be stemming from those investments and from the commercial transactions. Julien has mentioned the possibility of reviving or revitalizing the WTO as the possible forum for the trade disputes, but I would like to possibly come back to Helena's comment related to arbitration. You have mentioned that you are already seeing the influx of the Belt and Road related cases, and there is no doubt, of course, that arbitration is going to be a major mechanism for addressing those disputes. My question, and the question of many, I believe, foreign partners to Chinese companies, is who is going to resolve those disputes? I'm asking this question particularly in the context of the status of the offshore arbitral institutions in mainland China, which, as we know, remains unclear or debatable. I would like to ask about it in the context of the pilot free trade zones and in the context of the Supreme People's Court of China's opinion of December 30th, 2016 on the provision of judicial safeguards for the construction of free trade zones. Do you think that what we're witnessing is like emergence of a perhaps like more coherent policy of internationalizing mainland Chinese arbitration, admitting more of the offshore institutions through the free trade zones, or is it more like experimenting with the possibilities in this regard?
Very good question. Yeah, I think as to those disputes, whether we have those disputes, there are certain sub-questions related to your question. Whether it is possible to, or whether it is desirable for the parties to have the dispute resolved in mainland China or outside of mainland China. One of the key concerns is that if the dispute is resolved in mainland China by arbitration, the Chinese arbitration law and the related judicial interpretations, etc., would be applicable. No matter that's administered by arbitration institution in the free trade zone or outside of the free trade zone. So it is very important that the Chinese court would need to would need to behave in a way that the foreigner would have confidence in the Chinese arbitration legal framework and the practice, to believe that the Chinese court would supervise arbitration taking place in mainland China properly, would not arbitrarily refuse to enforce the arbitral award, and would not arbitrarily vacate an arbitral award made in mainland China. That is important, and I believe that SPC understand the importance of that. That's why the SPC issued a judicial interpretation saying that if that's about if the lower court plan to vacate an award on the ground of social and the public interest, this kind of matter has to be reported all the way up to the SPC, no matter that's a foreign-related arbitration or domestic arbitration. And also, there's cost issues. Yeah, if you have arbitration administered by CTEC or BAC, other Chinese arbitration institution, the cost of arbitration is significantly lower than you have arbitration administered by ICC or SIIC, HKIAC. That's because their fee schedule is different. Yeah, so. It is also important for those Chinese arbitration institutions. They need to be able to administer the case properly. When I say properly, not only in terms of procedure, but also in terms of how they appoint say the presiding arbitrator, when both parties cannot reach agreement on the sole arbitrator or a presiding arbitrator, because of course the party would like to resolve their disputes at a lower cost, but however it is also or even more important for them to have the case arbitrated in a fair way. So that would be one of the concerns, especially to the foreign parties. And as to the judicial the regulation that you refer to, I think that refers to the so-called the three certainties. You have if the party agree to a set of certain rule to have the arbitration arbitrated by certain people. In a certain place in mainland China. But so far, at least to the best of my knowledge, I haven't seen any case being arbitrated under this new regulation. Some people say this new regulation actually allows ad hoc arbitration in mainland China, but without a successful precedent. I as a practitioner, I would not suggest my client to do it this way, because it runs the risk. So we are waiting for someone to set a proper example for us. Then we know, oh, this But with this uncertainty, I actually do have doubt, at least at this stage, I do have the doubt on how this can be properly conducted in mainland China.
Can I say something about arbitration too?
Yes, of course.
Sure. Just to add on to what Helena has said, and I'm sure that Professor Zhao has also a lot to say as authority on Chinese commercial arbitration law. My personal observation myself as an arbitrator in CTAC and Beijing Arbitration Commission, and also attending overseas arbitration, my observation is that Chinese arbitration circle has gone over some changes over the years. China started, arbitration as a government-controlled arbitration before 1995, and that is what they understand as arbitration. But now that is gone. That is history. After 1945, with the establishment of local arbitration commissions, as exemplified by the Beijing Arbitration Commission under the leadership of Wang Hongsong, there is a trend of trying to move towards a affiliation from the government to try to make arbitration independent. And I think that's what is happening. I think that's also a good trend. But what China has not really probably cleared in this concept is still that China still think that arbitration is more arbitration is an event, is an activity administered and run by the arbitration institution. But actually, it is not. It is really a contractual thing, as parties contractually agree as to what they want to do. A typical thing is ad hoc, but then even for institutional arbitration, the institution is just providing the administrative support, not necessarily being run by the institution. I think that's the goal. But I think that Chinese practitioners and arbitrators and professors have not really gone through that yet. So I think that probably the Supreme Court is probably more liberal in that, even allowing the ICC arbitration in China, taking a liberal, view in some cases. And I think that, that was probably going to be happening in the future. In arbitration, my personal view is that China should adopt the view of 引进来 to get people in, meaning that we should probably allow the international arbitration institution to come into China to compete in China with other domestic arbitration institutions in a way that this can try to increase the quality of Chinese arbitrators and practitioners. This is like under the WTO within the arbitration sector, I think. But then on the other hand, I think we cannot deny the fact that because the arbitration clause as being perceived by parties to transactions, they will probably still try to choose arbitration forum outside China because, for many deals from Chinese investors into those host countries, it's very difficult for them to accept arbitration clause with a seat in China because it's perceived to be not giving them the comfort. So I think, maybe Helena will continue to observe this. Yesterday, saying that she said to me that probably, as a matter of practical issue, in the future we will see more likely the parties in the BRI transactions choosing the neutral, international, famous forum as the forum for arbitration, like SEC in Sweden, like Zurich, like LCIA, like the Singapore, and like Hong Kong. Okay, so yeah, Dubai, yes. So in a way that this is going to be what will end up, and I think that this will give Chinese companies and practitioners and arbitrators a big challenge that we should be able to cope with this and then to go out. This is 走出去. This is another. The legal sector. We should also 走出去. Go outside. Okay, and try to work with international community, with the famous professors here, with the arbitration authorities, with the legal community, and trying to to get into those dispute resolution work involving Chinese parties. And I think that's the future. And I think that we're lucky all together to be part of that. And I think that that's what I look towards, more cooperation with you in the future.
You first.
Yeah.
You first.
I just wanted to make a very brief point there. I agree with all of that. I think the challenge actually for the Chinese institutions is to become the neutral third party. So say you have a deal between Kazakhstan and Turkmenistan, how do you then, as a Chinese institution, become the neutral institution to which the parties are prepared to submit the dispute? I think that's really going to be the challenge, because as you say, if it's between Turkmenistan and China, then there's always going to be a bit of reluctance to have it go back to China. It might if the Chinese banks apply pressure, but that's not the way to build a successful relationship. So you were talking yesterday about the BAC going around doing publicity things in Europe. Maybe they should be focusing on the Central Asian states as their next target.
Yeah, thanks.
Yeah, certainly. As to Middle East, because a lot of OBOR countries are very close to the Middle East, and actually after this meeting, I'm flying to Dubai tomorrow. The reason why I'm flying to Dubai is actually because I'm representing an SOE in 2 arbitrations administered by DIAC, Dubai International Arbitration Center. And while we are talking about, say, if we have the place of arbitration in mainland China, the foreigners concerned about, if they are, what are those special regulations on the PRC law? Similarly, if you have an arbitration seated in Dubai, there are actually a lot of special regulations in Dubai. The law in Dubai the arbitration law in Dubai is not the same as what we generally think about, for example, the arbitration law in Hong Kong or Singapore, because they are model law countries. For example, the witness, if you have arbitration in Dubai, and then the witness have to give their evidence under oath. If that's not under oath, and then you run the risk of the arbitration award being vacated by a court in Dubai. And Yes, not in the name of Allah, because they also respect people might have different religion. But however, it has to be taken under oath, and there are special regulations about interest, etc. I'm not the expert in this because I'm representing parties. Yeah, so there are special. There are several special regulations that we need to pay attention to. So it's very interesting that although when we think about arbitration in Hong Kong or Singapore, we think, that's the word that we are more familiar with. But while we are, if the parties agree to arbitrate in, say, in Dubai or say in Indonesia, there are special regulations that we really need to pay attention to.
I want to ask Helena a question. In the Islamic world, I heard that they don't allow female arbitrators; they only allow male arbitrators. Is that no? No such thing.
No, that's not.
I'm just curious.
Okay.
And you can represent parties in those arbitrations.
Okay, yeah.
You don't need to
I'm qualified. So.
Okay.
There are actually some very
Yeah.
well-respected
Really?
female arbitrators.
Yeah.
Mhm.
Very interesting point, actually, raised just by Mr. Zhang, because after having gone through some specific subject topics in the panel, I would like to, provide a platform for discussing some general issues, which is actually relevant to culture, which Mr. Zhang has just, raised up. So, probably some of you were here yesterday. We have a dedicated session of our 2 days events addressing the cultural aspect of the role of China in international dispute resolution. So today I would like to also briefly discuss with our panelists about the role of culture as a bridge between China and its partner countries. As we know that we have the ancient Silk Road serves actually as a passage of exchange of culture of two civilizations between China and the rest of the world. To my understanding, this Belt and Road Initiative can be seen, as a new bridge to connect, China and Europe. I think, because since we are talking about connectivities, talking about collaborations, we do not simply put China and the EU as, two commercial players, as, trade partners. We more likely to see those two players as two civilizations. So we're talking about also, collaborations and, a platform for people to people in terms of the exchange of ideas. So I would like to ask, a general question, and what do you think about the role of Belt and Road Initiative to serve as a bridge between China and the rest of the world? Thank you.
Again, I start first. Yeah. Thank you. Yeah, the cultural perspective of the BRI, I think, is a very broad, not probably well defined. And I see myself, the issue actually touch upon different, multiple facet of culture, and I think law is one typical embodiment of the culture. And then, in the parameters of the cultural issues, I think there will be religion, there will be thinking, and then a way to do things, and how the political structure, as well as the various other issues. If you look at the religion along the route, actually you see the Asian countries, which is really very diversified, and then India is Hindu religion, and then Central Asia, and the Eastern Bloc, probably more the Orthodox religion, and then coming to Western Europe, and then that's more Christianity. So it's really the religions believe and having a big play in the cultural issues. And I think that China should be very aware of those cultural differences and respect those differences. And I think that if you look at many investment deals, most of them, the reason is the integration after the closing of the transaction, but how they integrate in operation, that's more critical. So when it comes to operation and integration after the closing, that really require a long-term efforts, and try to deal with the local partners and the government and other and the consumers in the society, and that, I think, the role of paying cultural respect and compliance is really more important.
I have to say I find this question of legal culture rather difficult. When I was myself in high school, my mother taught at a big Australian high school in which 54 different languages were spoken. We're an immigrant country, so you just have to try and extend some tolerance to all sorts of other people. And also, if you look at the Asian region alone, the Regional Comprehensive Economic Partnership has 16 countries negotiating, ranging from China down through to Australia and New Zealand. And I guess the only two which really have the same culture are Australia and New Zealand. And even then the New Zealanders would say that they have a completely different culture of their own. So I think it's really impossible to actually be totally sensitive to other people's culture. And I was a little bit, and I think your initial comment when you were talking about China and the rest of the world, perhaps, if I may say so, presents one of the issues there. Because I think in terms of culture, the most successful way that you deal with integrating cultures is, to my mind, food and education, right? Those are areas in which we can all agree. But the prospects for making enemies through business and investment seem to me actually to be extraordinarily high. As Libin says, you get a joint venture in China, everybody starts off with the best intentions, the negotiating team goes home, and then it all falls to pieces. Because in fact neither side really made the effort to work out what the other one wanted in the first place. So I think that given all of the various different cultures, religions, and all of the rest along the way, there are prospects, I would say, for a lot of mutual education to be going on for the next few years. But there is really no simple answer to how you would resolve all of those different issues.
Culture to me is a very difficult topic.
Exactly, it's also difficult for all of us, I guess.
Well, again, I can only share experience that I learned from my clients. Yeah. One of the things that they told me is that when we were discussing about going to a country in Africa, and then I said, how I go there, etc., etc. I said, Helena, you don't need to worry about it. You know, in the airport in that African country, you don't need to speak those local language. You just speak Chinese, and then the people will help you. Well, language is a part of culture, I believe. Yeah. And the other thing is, say, for example, in a project, they are building highway. They have a group of Chinese workers and a group of local workers. One of the tasks for the project manager is to keep those two group of people in peace with each other, don't fight with each other. Because they have some different culture. And then sometimes there are conflicts. And then so by doing so, actually, I believe they are learning from each other's culture. Yeah. So as long as there are a context between people, and then I believe naturally, maybe sometimes there will be some difficult times, be conflicts, but as time goes by, people learn and understand and try to understand each other. So I think culture, it just goes naturally. Yeah. Or not, yeah.
Or not, yeah. Well, culture, in fact, implies exchanges. A culture that is closed on itself is a culture that's going to die, and that's not very interesting. Cultures are always evolving, so they need to be open. They need to be open to influences, counter influences, and yes, I guess the BRI, to some extent, will contribute to help people abroad to better understand the Chinese culture, and vice versa. The Chinese will better understand many, many other cultures. My wish is that we maintain this pluralism and the great diversity in terms of cultures. We should never think or hope for one culture to take over all the others, because that's something that would be very sad, in fact, for all of us. That being said, also, I think the BRI is just another factor that can really have a positive impact on cultural exchanges. But I'm sure that here in Denmark or in many other places, many people knew about the Chinese writers, painters a long time ago, and vice versa. In China, people knew about what is truly important, arts, against writers, painters, even before for the BRI. So things will go on. I think at the very global level, what I think is good from my point of view is that we have a big rebalancing, and from the risk of having one prevalent culture, American one perhaps. I'm going to look like anti-American this morning, which is not the case. Yeah, there is a rebalancing and a greater interest for many people in the West, for instance, about what's happening in China and the rest of Asia, and that is good in itself, I think.
Can I add one thing that come to my mind? And yesterday I met a friend, in a hotel, who is a very, famous, a music events organizer in Copenhagen. And he told me that tomorrow there's going to be a Chinese rock band coming to play in Copenhagen. And he has been working actually for 12 years, sending, Danish, jazz musicians to China. And they organized the jazz festival in Beijing. And he told me that actually, the jazz is a universal language, which doesn't really have the barriers of culture. And I think that in spite of the diversity and the barriers which is set up by the different cultural background, I think there's something universal, probably just reflected in the music and also art, that we do have something in common as human beings in the world. That we're also seeking happiness. We want to live peacefully with neighbors and live in a good environment. And I think that that's something we have in common.
Yeah, thanks.
Well, I would actually like to say that it seems that this need to acknowledge or accommodate diversity that you have all mentioned as such a paramount goal is also quite officially recognized. I would like to quote this famous excerpt from President Xi Jinping's speech at the recently concluded 19th National Congress of the Communist Party of China, where, among other things, he said that he commented on how China has developed its economic model without imitating the Western values. And he said that China offers a new option for other countries and nations who want to speed up their development while preserving their independence. So this has been quite widely commented upon as acknowledgement or acceptance of the diversity of the political and economic models of the partners collaborating with China on those trade and investment ventures. And actually many of the Western commentators said that it might be signaling this like assumption of the or the wish of China to assume the role of the pioneer of the new version of globalization that actually accepts or assumes this diversity. Do you think that this might be happening? That this grand vision might be actually realized?
Okay, thank you. So realist, that's a big question. But for instance, what I observe, it's a bit technical, but I think it's a good example. China has pioneered or has been very active in development of special economic zones from the very beginning of its opening up to now with different types of zones, right, until the pilot zones. But what I find very interesting is that a number of jurisdictions in Asia, like Vietnam, Thailand, and a few others, have recently developed new zones. In the case of Vietnam, I think it's 3 zones which were created as of January 2016, and for Thailand, 5 new zones last year. And there will be a few more examples. And all of them, when you talk to them, when you talk to the zones designers and it sounds like fashion, but those who design the zones and think about their operations, they all say that China has been the benchmark, I think, in the creation of these zones. So I think that, taking a very technical example, practical one dealing with trade issues, yes, China has become a laboratory in terms of economic development, and recently, you can find a number of examples of countries that try to duplicate or replicate what was done in China, hoping that they will achieve also the same goals. And I think it's, one example that shows that, yes, China is another option. It's a way, for instance, to deal with trade that does not correspond to the North American way or some of the things that were done in the EU in terms of economic integration, for instance.
I think someone actually has to point out that you cannot, in fact, separate trade and human rights. The Chinese have done a great job of trying to separate the two. But in fact, when it comes to practicalities, the Chinese are in fact very prepared to mix trade and politics and to have a world view which says, look, we've done it our way, so don't pay any attention to what we do and we won't pay any attention to what you do. I think ultimately is convenient, perhaps, particularly for those of us who are interested in trade and for business people who are also interested in trade. But I think that we really can't let the conference go by without mentioning the fact that the vision in relation to China's trade and to China's investment also overlies the very obvious problems within the legal system itself, which means that dissidence or speech in relation to human rights and so on doesn't actually find a place within the system. So when you're talking about the certainty of the courts and reliance on the courts, we can't forget that the courts may try to establish a reputation for certainty when it comes to trade and business matters, but can you actually maintain that reputation when underlying it is the fact that the courts are told what to do when it comes to all sorts of different issues, for example, criminal trials. So I really think that also has to be borne in mind when we talk about the export of the China model, that it ignores all sorts of uncomfortable things that we really shouldn't ignore ourselves.
Can I add some my own dimension and towards this issue. I think that Vivienne is correct, pointing out that the human rights issue in China is not good enough, and I would put the word just not good enough. But doesn't mean that it's not it's good. Okay, and I think that to be frank with you, if I myself changed my profession from an economic lawyer to a human rights lawyer, I wouldn't probably just my life would not be as safe as what I'm now. Right? Okay, so. But I'm a person who was born in 1960s and gone through the ending of the Cultural Revolution, and I remember my childhood years just learning the Red Guards, Mao's little red books, and then we gone through the opening up, and I went abroad to study in the U.S. and came back. So we see the changes in China over the past years, and I think that there are progresses being made. Okay, we start in terms of legal development from zero, nothing, at the end of the Cultural Revolution to what we have now. It's a huge body of law being built up over the years, and that actually gave us opportunity to practice law in China right now, and also gave many foreign practitioners like Helena, being in Beijing and handling China cases. Otherwise, we'll be out of jobs, I think. But having said that, okay, I think that China is in transition towards a new modern society, and I think that in that I'm pointing towards a rule of law and also constitutionalism. And my reason of going back to China after graduate is that I take that as a mission. But China is probably in this philosophy basis has moved from the Mao-type radical communism towards a more pragmatism right now. But then, because of the size of the company, the whole country, trying to not to run into chaos, but try to move more in a way which could be controlled. If that's what is they're giving a reason for justification of what we have right now, I think I can buy that. But I think that that's not the future, though. I think that the future would probably be more towards the rule of law and constitution. But then where does the Confucianism is based? And I think that in the way that Japan probably gave a good model in that they are modernizing their legal system at the same time, they're still maintaining their good traditional system, like mediation is what they have in the Meiji era, which they learned from China. So this is something I think China should learn, that we should probably combine the good element of Confucianism and then try to make it compatible with external societal model and state model of based on rule of law and constitutionalism. I think that's where the future is, and I hope that China will come out that way, and I see that for human rights, I think that let's give China some time.
And at this point, I would like
Someone else was arrested yesterday.
I would like to conclude the discussion on our side, and thank you so much for your comments, and open the floor for the questions from the audience.
Thank you. My name is Jose Rosell, and I would like to come back to the discussion on arbitration dispute resolution in China. I think Helena Chen mentioned the cost issue. And if I understood you correctly, you said CTAC is less expensive than the other international arbitration institutions. I don't think that the parties are concerned so much about cost. Certainly they are, but that's not the driving factor. Driving factor is confidence. And to send a strong message to the international arbitration community and to the foreign investors would be to amend the Arbitration Act. The Arbitration Act, which is dated 1994, although amended in 2002. But nonetheless, it is far away from being a model law system, a model law country. And therefore, unless we or the Chinese now government decide to amend the arbitration law and allow the international institutions to administer arbitrations in China with seats in mainland China, I think that will be difficult, very much difficult for foreign investors to be convinced to accept for major investments arbitration in China. That will continue to prefer to have Hong Kong, for example, due to the protocol between Hong Kong and mainland China regarding the enforcement of international awards. So I think that the faculties in Beijing and in other major cities should play a strong role there and continue lobbying, because we desperately need a new change there.
Is there a question? I thought it's a comment, but however, I'd like to respond to that. Yes, I agree with you that a cost could be one of the concerns, but certainly it would not be the driving force. The confidence would be more important. And although the PRC arbitration law haven't been significantly amended in the past 20 years, but I have also seen that the Supreme People's Court has done a lot of job by rendering judicial interpretations, etc. Say, for example, traditionally, the parties can only appoint people listed on the panel of on the panel of arbitrators, but now it has already been changed a couple years ago already that the parties can appoint people who are not listed, provided that is approved by the chairman of the arbitration commission. And as another example, under the PRC arbitration law, the tribunal does not have the authority of so-called competence. But however, according to CTEC arbitration rules, they say, the tribunal can decide their own jurisdiction, competence, because the arbitration institution delegates such right to the arbitration tribunal. So by the rules in the arbitration rules or the judicial interpretations, the practice are trying. The arbitration institutions and the court, especially the SPC, are trying to respond to the need in practice. And another point that I'd try to raise is about provisional like injunctions. If the place of arbitration is in mainland China, it is possible for a party to apply for provisional measures to seize upon the other party's assets in mainland China before or after the arbitration is commenced under PRC law. But however, so far, if the place of arbitration is seated outside of mainland China, the party cannot apply for provisional injunctions to seize upon the other party's assets located in mainland China. That might also be a part of the concern, a part of the party's concerns. So there are various factors that a party need to take into consideration before when they are negotiating the arbitration clause with the contracting party. A lot of things are taking place, and in each and every case, the major concern of the party might be slightly different.
I would like to add, some 3 points in addition to what Helena just mentioned. As you really correctly mentioned, that the China arbitration institution. Arbitration rules play a big role. Before we adopt ad hoc, I think that we have to to pay attention to those arbitration rules adopted by the arbitration institutions. But if you look at the rules of BAC and also CTAC, they have been changing very frequently. I think that each change is towards a more international standard, as exemplified in the ancestral model law. And I think that ancestral model law was taken into consideration when China first drafted the arbitration law in 1994. And even though there are some big gaps, but I think that over the years the change is in towards that direction. The other factor, which I think to give some more confidence, is that the judiciary system in China should be supporting the arbitration. And for domestic arbitration, we see some energy cases where the judges sometimes reject the awards domestically made more easily than the foreign awards. And I have actually have one case where, for example, two companies, having a trade in diesel oil, and as traders, they all both have qualification requirement. And if they don't have qualification and then they couldn't enter into the contract, there's an issue of whether if they don't have qualification, whether the contract they entered is valid or not. And in one case where both parties agree that they can do away with the qualification requirement, they enter into transaction. So the first two deals goes very smoothly, but the third one goes wrong, and then one party changes mind and prices changes, so doesn't want to sell anymore. So that party, which is subject to the claim of breach of liability, is using the government policy requiring the qualification requirement as a basis based on public interest to invalidate the award. And even though the arbitration tribunal reject that defense, but eventually the judge adopt that basis and then refuse to enforce that award. So you're seeing that actually the judges sometimes is not really having the observation that the energy sector is moving towards a more liberal direction, and still trying to being very conservative and based on the positive law and make such a decision. So in that situation, the tension between the court and the arbitrator is still there. So I think that the recent change of the judges being more supportive of arbitration award actually is a good sign, and I think that probably boosts the confidence of China as an arbitration forum. Third, but lastly, is also probably the most important one, as we all know in the energy circle, is that what it matters is that you should have good arbitrators eventually. Doesn't matter where you are. So I see that as a good example that so in China, I think that it is our task, and also our efforts should be made trying to train to have more good arbitrators, so that we can give confidence to people who are choosing China as an arbitration forum.
And we have space for one more question.
Thank you. In view of the place of human rights, particularly in the mining and extractive industries, where I think China is a major player, to what extent can we continue to wait for China to observe international human rights standards, knowing fully well that violations of human rights are a major source of disputes in all these places where this production takes place, particularly among the indigenous people living in those areas? To what extent shall we continue to wait?
It's
Question?
Could you please repeat the question? Yeah.
What I'm saying is that Professor Vivienne mentioned the issue of China separating, I think, their ability to separate human rights from trade. And I said, in view of the fact that, in view of the place of human rights in the extractive and mining industries, where China industries, NOCs, are major players, I now ask the question, to what extent shall we continue to wait for China to observe international human rights standards, knowing full well that violation of human rights are a major source of disputes in all these developing countries where most of these energy are based? That is the question.
Thank you. Perhaps I could follow up with his question to make up a little bit about his point. Since China has many investments in African countries, including Nigeria, and some of those investments go into the field of mining, coal mining, and some of you might have seen in the past few years in China that there have been many mining accidents in which many coal miners were somehow harmed underground, and in some cases lead to a huge number of deaths. So I guess if I took him right, is how to ensure that the Chinese investments in mining industry might be consistent with the human rights protection principle for this group of minorities or those co-workers.
I think that's a great question, and I suspect that you probably have more theories about this than I do, since it's something which you're dealing with on a regular basis. I mean, I have to say that all of the rules which have been issued by the Chinese government about outbound investment do make a point of saying that Chinese enterprises must obey local laws relating to labour. Increasingly, they give priority to environmental issues, to respecting local laws and customs and so on. But as far as I can see, there is a bit of a culture problem, and I don't think the Chinese enterprises actually are alone in this, but they are the biggest group now probably in these countries. So I think it's a two-way thing. I suppose first, in terms of bilateral investment treaties, there has to be more emphasis given to the rights or the obligations of the investors. And I think that new treaties, and I think Nigeria might be a forerunner in this actually, that new treaties do actually make clear that investors have obligations too in relation to the way in which they behave in terms of their investments. But I think also that there has to be potentially more effort on the part of the host country when they sign the agreements, both to provide the adequate information in relation to what the obligations are for labour, but also to make sure that funds are available, potentially as part of the investment, to provide the inspectors and the supervisors and the infrastructure which is required to actually make sure that safety requirements, that labour rules and so on are observed on these particular sites. So I think that there's got to be a responsibility both ways in relation to this. But I also do think that in this, the Chinese government is aware that this is a problem and that this is a massive issue for them in terms of perception for these investments. But as to whether there's one single answer to it, I really couldn't say. In fact, your views on this, I think, would probably be of more value than mine. Anyone else want to deal with this difficult issue? You're the one who's been to Africa. Yeah. See, no one else will touch this one. So,
well, in that case, I would like to thank the audience very warmly for excellent questions, for joining us here today. I would like to thank once again the panelists for the great comments and insights. And I would like to conclude our session here. Thank you so much.